Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of September the 19th, 2013. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. The board would ask everyone present if you would either silence or turn off your cell phones so as not to disrupt today's proceedings. Honestly, the gentleman in the striped shirt toward me, you probably don't have any signal from this point forward anyway, so you're just killing your battery letting it run. But if you don't mind, if you'll just turn that down so it doesn't go off during the meeting. The procedure will be to introduce the case record as the Codes Department has it on the wall here by means of a PowerPoint presentation. We'll present any maps, photographs, pictures of today's cases. We'll also present to the board any letters we've received in support or opposition to a particular case, as well as any correspondence we've received from other government agencies. At the conclusion of our presentation, the applicant will come first to the table before me here, along with any persons in support. And if there's opposition present, after the appellant comes up, the opposition will have a period to speak to the board. And then after the opposition has presented their case, the applicant shall have a period for rebuttal. The board in their rules provides applicants in cases without opposition 10 minutes to present their testimony. And the board also provides in cases with opposition, each side of a case is allotted 15 minutes. So if you have multiple speakers, please divide your 15 minutes accordingly before you come up here. The board would appreciate that. All section numbers that I refer to today come directly from Title 17 of the Metro Code of Law. Title 17 is the zoning code and was adopted by the Metro Council and became effective on January 1st, 1998. And applies to the entire jurisdiction of Metro government. I'll introduce and make a part of the record the entire zoning code and will dispense from reading individual sections unless the applicants or opposition or the board requests that I read those sections in their entirety. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board, please come forward. Your microphone looks just like mine. To the right, there are two buttons on that mic stand. The right one is speak. You'll notice the red light comes on. Your mic is hot, and give your testimony. When you're done, if you'll please turn that off. I'd appreciate it. If you forget, I can control it over here. Should be noted that it's found anyone presented false or misleading testimony to this board that may have affected this board's decision. Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for the public hearing today, and after each case, the board will then discuss and then vote on that case. The board is vested with the power to act on the cases before us as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of the 7-member be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your request. As it stands today, I have 5 members present. You need 4 of the 5 members present today to vote for your request. In the event that you do not receive 4 votes today, your case is deferred. Will remain on our agenda for the next 30 days. However many meetings we have in 30 days, usually 1, sometimes 2 in a 30-day period. Any of these 5 are allowed to change their vote. The 2 members that are not present are allowed to review today's record and become eligible at the next hearing, and then they can vote on your case. If after that 30-day period no one's changed their vote and no one's become eligible to participate and you still have fewer than 4 affirmative votes, your case is deemed denied by operation of law. Any appellant or aggrieved property owner may request a rehearing within 60 days of today's public hearing. Additionally, any aggrieved property owner or appellant may appeal this board's decision to Chancery or Circuit Court within the same 60-day period, but once that 60 days has elapsed, this board's decision is final. No further action may be taken. If you're an applicant and your case is granted, it is necessary for you to obtain the permit for which you've applied. It should be noted you have 2 years from today to pick up such permit for this board's approval to remain valid. If you fail to pick up your permit within 2 years, you'll have to come back and start this process over again. Mr. Chairman, I submit that all cases have been filed in proper order. Applicants were notified as certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean as required by the code. I do have some preliminary announcements. The board does allow elected officials to address the board. Do you wish to address the board before we get started? Or okay, please come forward, Councilman.
about case number 2013-051. I've talked to Mr. Seffer about his building that he wants to build, and I have asked him to drop this at this point in time due to the fact that I would like to get a traffic study of Nolensville Road and Peachtree and Melrose in that area. It really needs to be done. And also to get a real, have a community meeting about this where the people can really talk about this. And that's what I'd ask Mr. Seffer to do, and I think that we've come in agreement to do that today. But that's all I'd like to say. Thank you.
All right. Thank you for playing a role in it.
Yes. Good to see you guys today.
Good to see you. Thank you.
Thank you for coming to visit us today. I think it's your first time here, isn't it?
Yes, it is.
All right.
Come back. We're very friendly.
Any other elected officials present who wish to address the board? Okay. Seeing none, I do have some preliminary announcements. One of those the councilman alluded to is the withdrawal of the case, and also I'll deal with that first. The applicant has requested a withdrawal of this case, 2013, number 51, at the bottom of page 3. Mr. Seffer at 2326 Nolensville Pike. He will withdraw this case and refile once he is ready. So that case 51 will not be heard today. And also received a request for deferral from the applicant on case 94, requesting a deferral for 2 meetings. And Mr. Chairman, that's the only thing I'll need a motion on, case 94. Any other parties present? Case 94 on Gallatin Pike. Yes, Gallatin Pike. Okay, Mr. Chairman, there are no other parties present in that case.
Okay, so we've got a motion to defer for 2 meetings. Is there a second?
Second.
Got a motion, got a second. All in favor?
Aye.
Any opposed? Passes.
Okay, the case will be set 17th of October is the date for that. The case will be heard at the end of the agenda, that date. Okay, so case 94 will not be heard today. With that, I do have the board has a consent agenda. Prior to today's hearing, board member reviews the record in the case, and if in their opinion the applicant has qualifies for the relief that they've sought and they feel that material evidence would not change the grounds for an appeal, the board member recommends the case for consent to the remainder of the board. I will now enter at those times the cases Mr. Whitson has reviewed, and if there's anyone here in opposition to cases that I call, please raise your hand. We'll remove those cases from the consent agenda. The first case recommended for the consent agenda is case 2013-89, Kevin Corman at 131 Page Road. Is there anyone here in opposition to the case on Page Road, case 89? Mr. Chairman, seeing none, this case recommended for a consent agenda based upon the topographic conditions of the site. The next case recommended for the consent agenda is case 2013-90, Ms. Heidi Dixner and Corn Sweat Partners, the owners of the property at 315 Hermitage Avenue. Is anyone here in opposition to case 90 on Hermitage Avenue? Questions? All right. I will, if the applicant would please, if you saw a gentleman back there, if you guys will feel free to talk, we'll remove that from consent and put it back on the agenda. The next case recommended for the consent agenda is case 2013-91, Ms. Rebecca Daniel, appellant owner of the property located at 1912 Brook Meadow Court. Yes, you're the applicant? Okay. Are there any other parties opposed to case 91 present? Okay. Seeing none, Mr. Chairman, the shallowness of the lot necessitates a need for variance in this case, and Mr. Whitson recommends that case for consent. And finally, case 2013-93, Jarvis Sign Company, 1701 West End, requesting variance and street setback to install a non-illuminated logo at 1701 West End Avenue. Anyone here in opposition to case 93? Mr. Chairman, seeing none. That case 93 is recommended for consent as well. We will, again, those cases 89, 91, 93 3 currently on consent.
Okay, so we have a motion for consent. Is there a second?
Second.
Got a motion, got a second. All in favor? Aye. Any opposed? Passes.
Let the record reflect, we have a full complement of board members here that heard that case. So if you're here for cases 89, 91, and 93, your cases have been approved. It is necessary for you all to follow up with the Codes Department beginning on Monday morning to obtain permits if necessary. Mr. Corman, there is no permit required for a fence.
Any record of the approval?
Yes. A letter will come from our office first of next week to the address that you provided us with the board's formal approval written out there. So if you're here for cases 89, 91, and 93, your cases have been approved. You are free to go. You're also free to stay if you want to and hang out with us. But all right. Mr. Chairman, we'll queue up the first case on today's agenda is case 2013-70. On the front of page 1, Jocelyn Sign Company, the appellant, Frankie Matthews, and Russell Seagraves, the owner of the property at 1300 Gallatin Pike. They are appealing the zoning administrator's interpretation of the code as it relates to LED signs permitted with used car sales land use, and additionally, if successful, would be asking variances in the distance to residential separation in the CS zoning district to install a new 19 by 11 ground sign.
Joey, can I ask a question?
Certainly.
I mean, since this is going to be a lengthy case, did case 90 resolve itself?
Case 90?
Yes, it did.
Okay. All right, thank you guys for talking with each other. With that, Mr. Chairman, we'll put case 90 back on the consent agenda.
Okay.
And second, please.
So, motion to amend the consent agenda, is there a second?
Second.
Okay, I've got a motion, got a second. All in favor? Aye. Passes.
Okay.
Congratulations.
You adopt. Case 90 is approved. Ms. Dixner, follow back up with the Codes Department beginning on Monday with your permit. Okay. This is an item A appeal. The zoning administrator, we modified our procedure a little bit. So the zoning administrator will first come or sit where he's sitting. That's fine too. We should make you come to the big table. No, that's okay. And I'll turn over to him first. He is timed, so he gets 15 minutes to present his case, and then we'll turn over to the appellant, and then any other parties will also have an additional 15 minutes after the appellant goes. Only the appellant and appellant's reps will have the rebuttal period. So with that, I'll turn over to the, actually, let me show the photographs of the subject property, and I'll turn over to the zoning administrator. The subject property is located in the property shape there in red in the CS zone district. This is up in the Madison area, just north of Briley Parkway. The area photograph of the subject property shows the existing property here. The RCS Motor Company is in the front. I believe there's an additional tenant at the rear of the property here. Adjoining the property are other used car sales, land uses. Across the street is Spring Hill Cemetery, and to the south is the Veterans Cemetery there in Madison. I'm going to come back to this area in just a moment. Now, this you have before you a copy of a new exhibit. This was the original exhibit submitted by the appellant when they filed their appeal. They have since provided you a different graphic that shows the proposed signage. This is the subject property. Upon my visit there the day, placed the public hearing notice signs. And then adjoining properties, the car lots to the north and south. This view along Gallatin Pike looking north into Madison. And the existing ground sign that's on the property there. There are essentially two, this is a two-part appeal. First being the item A. For record-keeping purposes, it might be easier if you wouldn't mind in a motion separating the two items, just for help me out. But If successful in the item A, a variance will be needed on the spacing between the subject sign and the residential zoning that is nearby. The closest residentially zoned property is the Spring Hill Cemetery property, which you see where my cursor is located here. Both cemeteries, both the National Cemetery and Spring Hill are zoned residentially.
Yeah. Joey, I know we've gone over this before many times, but we have new board members, so kind of go over if something, obviously the federal cemetery or even the Spring Hill Cemetery is probably not ever going to be have houses there where people will live, but tell us how we are supposed to treat something that's zoned residential anyway.
Sure. For purposes, and I'm going to read this section of the code that talks about the provision before you today is located out of 1732-050, which is the prohibited sign section. The LED sign on the subject property is not allowed, not by this section, but not allowed under Council Bill 418, which the council just recently passed, that used car sales are prohibited from having LED signs on the premises, even though it's Zone CS, which is a permitted zoning district that does permit LED signs with certain requirements, or certain conditions, I guess I should say. 1732-050 sets forth those conditions under the prohibited sign section, and it is a function of the separation distance from residentially zoned property. As David alluded to, the zoning code does not look to the use of the property as the zoning code spells out. It says all residentially zoned property regardless of use. So if it's school, if it's cemetery, golf course, they're all treated the same.
I don't know the answer to this. I mean, maybe you do, Joey. Most cemeteries, are they residentially zoned, or what's the zoning for a cemetery? And
I would say in the county, if not residentially zoned, agriculturally zoned. I don't know of any, even on Lebanon Road, Mount Olivet Cemetery is residentially zoned as well. But 1732.
final resting place, right?
Yes, sir. 1732-050 sets forth that based upon the height of the sign, signs 4 feet or less in height shall not be more than 100 feet from any agriculturally or residentially zoned property. B sets forth for each additional foot in height or portion thereof above 4 feet, an additional setback of 25 feet from agricultural or residential zone property is required. The rest of the section deals with as far as scrolling and blinking lights. The applicant's not proposing anything like that, but it is the separation distance to the residentially zoned property. That's an issue here.
In the item A, appeal addresses this. How we're determining what exactly?
I'm sorry, sir.
The item A portion of this appeal is what exactly?
It deals with whether an LED is permitted on the property at all.
And didn't you just say that?
Well, there's a recent council bill that prohibits them on new car lots. I'm obviously not going to take from the appellant's argument. He's certainly going to argue differently. But
Okay. So that's the issue.
that is the A part of it. You will decide whether or not it's allowed, and if then variances upon distance.
I should have carved up before this.
Essentially, the record we have we have received 2 letters in opposition in the case file.
From the cemetery? I'm sorry.
And 3, excuse me. And then a letter in support for this case filed by the appellant. With that, I'll turn over first to the zoning administrator, and Mr. Herbert, you'll have 15 minutes to present your case.
Okay, we've got 2 appeals here. The first is an item A, and the second is a variance The proximity to the residentially zoned area, that distance requirements is the variance part of this, and so my item A has nothing to do with that. So let's take that proximity to the cemetery completely out of this analysis. Okay, going to the item A. The reason that I felt like that I could not approve this was because, and Joey alluded to it, is that we have a new ordinance, and it's BL 2013-418. And what this ordinance does is it pertains to CS-based zone districts, and prior to the adoption of this ordinance, certain automobile-related uses were not allowed under CS-based zone district. What this ordinance did was modify that and said that you can have certain automobile-related uses subject to certain conditions. So it made it a PC under the zoning code. So this ordinance became effective on May the 24th of 2013, and one of the provisions under the conditions for this states that billboards and/or digital signs are not permitted. So that's a condition that is associated with this new ordinance. I'm going to pass.
Not permitted for what?
Not permitted on the property at all.
Any use, any auto.
Of certain automobile-related uses.
That's what I was asking.
Okay.
Automobile-related uses.
Yeah, there's several of them here. And so automobile sales used is one of the categories. We have car washes. That's another category. We have vehicular renting and leasing is another category. We have vehicular sales and service limited. That's another category. So instead of going through all of this, there's a number of categories, but I think that you'll hear in this case, it's my understanding that this particular use is automobile sales used.
Okay.
So it doesn't apply to new cars, for example?
Correct. That's correct. So we've got this new condition that said no digital signs. This ordinance became effective May 24 of 2013. So based upon the adoption of this new ordinance, I felt like that I could not approve this administratively. Now, my opinion on this in no way considers any arguments that would be made under state law pursuant to 137208. I'm not taking any position on that. So to kind of summarize this, the basis of the item A begins and ends with ordinance BL 2013-418.
So you were able to say no before you considered 137208.
That is correct. I did, and let me say it. I did.
Let's say you weren't able to say no before you got there, because I have a feeling it's going to come up in a minute that we should consider 137208. And it's my understanding that based on the outstanding court case that we have a ruling in that is being appealed, that in that ruling it said that if that were the sole basis for an appeal, it wouldn't apply because it's not a zoning issue, it's a light and safety issue.
Correct.
And so that may be something we discuss in a minute, but you didn't get that far, and that logic, if you agree with that logic from the chancellor, could still be valid.
Correct.
Okay, that's just, I wanted to, okay.
Yeah, I just want to make it very clear here that the reason that I couldn't approve it, and it went no further than this ordinance right here. I did not go any further to analyze it under 137208. My analysis began and ended under this ordinance. Everybody good with that? Everybody understand? Mm-hmm. I'll pass it around. If anybody wants to see it, I'll flip it over to the applicable page. But you can glance through it.
And I guess just one more note about, this was, I guess, a car lot before
the law changed, so it was a non-conforming use, and then the law changed, and it's actually now perfectly legitimate, and so there's not any issue of, well, the sign was here before, and, I mean, once it became a conforming use based on this amended plan, then it has to follow the rules as the amended plan.
Correct. It's a conforming use now in that it's permitted with conditions.
Okay. Thank you.
Let me clarify. I may have been confused a little bit about that when you said that. This was a lot continuously owned by the same owner, correct? Is
Joey,
that
do you know
correct?
the answer to that?
I don't know the answer to that.
All right.
I think you need to hear from the applicant
Okay.
on the history. Again, I looked at it from the use.
Right, but it was a legal non-conforming use until this new councilmatic action.
It could have been, but I think you need to ask the applicant that. I
Okay.
don't know. I'm looking at the use that what they're proposing to use now,
Okay.
and then applied that ordinance to it.
Okay.
Okay. All right. I have no other questions, Zoning Administrator. His time's up. I'll turn it over to the appellant in this case. Come forward. Gentlemen, you'll have 15 minutes. Do remind you that of that 15, you're welcome to save some of that for a rebuttal. Once the appellants are through, any other parties wishing to address this case can come forward.
May I inquire at the front end, Mr. Harris, whether or not there is opposition that's going to address the board today?
Did not ask that. Opposition present who wishes to address board. We do, sir.
All right. Mr. Chairman, members of the commission, my name is Tom White. I'm with the law firm of Toon, Entricken & White. We represent the applicant in this case. At the outset, I'd like to confirm to the board, I sent a position paper down here to Mr. Hargis to be circulated to the board, which pretty well spells out our legal position in this matter. And I think it's a pretty straight application of 13.7.208. I don't think any of the lawyers are going to disagree that 13.7.208 would trump a metro ordinance or statute that's in opposition to it. With that said, I also want to confirm at the front end that to my right is Frankie Matthews, who's one of the owners of the property, and to his right is Mr. Ryan Taylor, who's a representative of Jostens Signs, who have proposed to put the sign on the property. For the record, and we'll certainly answer any questions, my client has owned the property with that use on there for in excess of 2.5 years, certainly long before the May 2013 enactment of the metro section, which was read by Mr. Herbert. I would also like to confirm that I've asked as an exhibit be passed to the board members that shows the current sign on the property as opposed to what's being proposed. I'll reference that for what it's worth in the board's consideration. The current sign is significantly larger than the sign that is proposed. It's about 150 feet of board face on the current sign. It's approximately 100 feet on the proposed digital sign that's before you. With respect to the legal argument, as was commented previously by Mr. Herbert, it was turned down administratively because, frankly, the administrator had no choice but to turn it down initially. Facially, it's non-compliant. The issue is whether or not 13.7.208 trumps the metro ordinance in this case. Again, it was turned down because it was, in fact, not allowed in this CS zone district, and secondly, because of the distance requirement to residential. As has been confirmed by the staff, the residential component here is the cemetery. And I noticed in one of the letters that was sent down in opposition, they said there might not be any opposition from the owners of the residential property. I think that's pretty much a given here, and we can probably take that as a foregone. And I don't know where the applicants live or where they requested information came from, but I can confirm to you that from my client and the staff, we're not aware of any opposition that has been voiced by anybody in that area. If there is some, we'll hear about it in a little bit, but I don't know of anybody who's responded, either for those notified within 300 feet or anybody in that councilmanic district. With respect to the issues again before the board, I want to address, first of all, that the actual sign ordinance itself, and this is found at the second page of the brief, I think even under the interpretation of the sign ordinance, it says that if the alteration or repair is caused by involuntary damage or casualty, or is desired by the owner of the business existing on the effective date of the ordinance. That's May of 2013. The 50% standard will not apply, and the sign may be altered or repaired to any extent. So the first argument that I'll make is that presume the state statute doesn't trump here. The very signed ordinance that we're referenced is very clear that this section will not apply if the owner requires it, and, quote, the sign may be altered or repaired to any extent. So basically, the Metro ordinance itself would allow it. With that said, I'll not read all the language from the Tennessee nonconforming statutes. They started in 1973. The board hears this argument on a regular basis. It came through many different alterations as it proceeded forward from 1973. Tennessee's is one of the more liberal nonconforming statutes, or grandfathering statutes, if you will, and we've outlined some of that history in the presentation which we have. I want to comment that with respect to that section, it not only allows for the non-conforming property to continue, but it allows it to expand. It can be reconstructed. It can be taken down to scratch and totally reconstructed. That's non-conforming use. And in this case, that's exactly what we have here, a non-conforming use. It was totally legal until this enactment of May of 2013. My opinion is even after the May 2013, when you look at that language, it's still appropriate for the reasons that I just read to you. With respect to the key part of 13.7.208, it's actually 13.7.208 sub D. This is the paragraph under the state statute. If you want to concede for a minute that there is an issue we cannot overcome on the Metro ordinance, and I submit that we clearly do overcome it, but if you want to say for a minute, what does 13.7.208 say? It's in section 208D. And that section is available. The zoning administrator and the staff are certainly conversant with it. It requires three things. The first thing is the use itself legally non-conforming? What I've attached to our brief are two letters from the staff of the Codes Department. The most recent is a letter of December 12, 2011 from Mr. Walter Morgan. It clearly confirms that this is a non-conforming use on the property. So the first step is there. It's that direct. The second one is, as a test under 13.7.208D, is the proposed use a nuisance? It can hardly be declared a nuisance in this case. There's been a sign there for years, which is 1.5 times larger than this sign, and I can't imagine anybody trying to construe this sign as a nuisance under what's already there and allowed. The third issue is it necessary for the business? My client is here. He will testify. What's happened is that there's a number of LED and digital signs on that corridor now. My client, as you saw in the pictures, got a very narrow shotgun piece of property, 100 feet in width, and by the time you go by there at any kind of speed, 40, I believe, is the speed limit, but 40 to 50, you're going to miss this sign, which is extensively high in the air. And so it's the width of the property, and it is the fact that there are other LED digital signs coming on board. One, the closest, is CVS, which is right down the street as a pharmacy. Now, with respect to other issues what the board has to consider, I did want to reference the board to, it's found on page 4 of the brief, and it's the case of National Auto Truck Stops versus Williamson County. This is a case that I know the zoning administrator and the staff are conversant with. This was an issue down at Goose Creek in Williamson County. It is this exact issue where the trial court denied the replacement of a sign. It was a sign on a piece of property on a truck stop down there at that interchange. The trial court did not allow them to put the sign back up. The Court of Appeals said very clearly it is a non-conforming sign, non-conforming use, and it's protected. In that case, it was an accessory use. But the court said primary or secondary doesn't make any difference. It's totally protected. There's no way this commission can construe that case as it's interpreted by the Court of Appeals and not allow this relief today. It's verbatim the same thing. Does Tennessee Code annotated trump the local statute? It's clear that it does. That court case makes it clear. That's the Court of Appeals for the middle section. With respect to other matters before the board, I would submit that my client has got a good track record for whatever it's worth. There's no violations or problems with this piece of property. You've seen the other uses in the area. A lot of them are used car uses. That's a use that's been vibrant out there. We don't know of any complaints either prior about our property or about this request, not just within the 300 feet notification period, but others. With that said, I'm going to ask that we be allowed whatever time for rebuttal. I do want to identify to my immediate right Frank Matthews as the owner. Let him confirm to you the business necessity of this sign.
Good afternoon. This is our third location. Our company has been in business for 10 years. We were first at Lafayette Street, then on Murfreesboro Road. We bought this property on Gallatin Road due to traffic count. The volume of business is lower on Gallatin Road than it was at either the other two locations. So this sign is going to be very vital to keeping my employees and their families fed. So we need the sign just to catch some attention.
We'll answer any questions. I do want to clarify that as far as the basic legal position, it is, and I don't know what's raised in prior matters down here before this board has allowed digital signs to replace billboards. This is far less offensive. It's a stationary sign with this replacement. Secondly, as I said, if someone can read the language in the sign ordinance and not agree with my interpretation, I'd like to hear it, because again, it says, if the alteration or repair is desired by the owner of the property, quote, then the ordinance codified will not apply, and the sign may be altered or repaired to any extent. That is just the Metro ordinance. Again, I think the state statute trumps it. And finally, I think the decision by the Court of Appeals for Middle Section in 2001 addresses it head on. We'll answer any questions. I realize there's folks that want to appear in opposition, but I would like to at least tell the board we'll answer any questions.
I've got you have a question?
You go ahead.
I think all of your arguments are very good. If it had no LED component, and I don't know that the LED component part of it has really been addressed, because I think if there were no LED component, we would be talking about only a variance and not an item A. And I really don't see that. I mean, in all the arguments, I don't see it. And, you know, the necessity piece of it kind of begged the question: if the LED part was that necessary, why isn't the whole sign LED, proposed to be LED? I guess what I'd like to know a little bit more is the argument about, if we're looking at just the LED piece of it, why is it a zoning issue? Because when we, as a board, said we're going to send it to the courts a couple years ago almost, and let them decide, the court that did decide, which is still, I guess, in the process of being appealed, that decision, said this isn't a zoning issue, it's a light and safety issue, and overturned us. And so that piece of it is still, I think it's relevant on the grandfather clause to us, and that part hasn't been addressed in what you've said. So I'd like some clarity on the LED part.
Sure. The first thing, as far as the position that we take today, I'm not totally conversant with the facts in the case that was appealed from here to the trial court. I do make the comment that the Court of Appeals, as the appellate body, is the one that I've cited for that 2001 case. With respect to the LED sign and the variance, I want to be clear that our legal argument is that if it is allowed under 13.7208, that trumps the item A part, and it trumps the variance request also. In other words, if it is allowed as legally non-conforming and it's grandfathered in, then it would not be obstructed by either the item A interpretation of the new ordinance or the distance requirement. Neither one of those would apply. The state statute would trump both of those, is my argument. With respect to if I understand why we want the LED sign as opposed to just a static sign, is that the question?
Well, I mean, I think I understand the desire, but I don't know that. I guess I'm not sure what the legal justification is for it. It was a 2001 case. Was that an LED sign, or was that just a static sign that you cited?
I am virtually positive it was a static sign.
It seems old enough that it probably would have been.
It was 2001. I'm virtually positive, and my law firm tried that case. It wasn't me, but that's why I'm so conversant with the decision. But I'm virtually positive it was static. I can't tell you differently than that. But as far as the LED component, as I said, if you look at the language in just the metro section itself, if it can be, quote, altered or repaired to any extent, then I believe that argument carries the day.
Right.
As far as why the client wants the LED, I think because of the narrowness, the 100-foot in width, and the fact that the current sign is so entirely high in the air that by the time you come around there, you can't see it. And it's an expensive sign. We're talking about $35,000 to $40,000. They're not doing that because they want to run up the cost.
Yeah, and I understand. I mean, I think the lower sign, it all makes sense, but it does seem like that it comes down to if you say, well, I can repair, I can rebuild a sign, do whatever, that fundamental to that argument is that an LED sign is the same. A sign's a sign's a sign. It's the same type of sign, and this board has agreed with that in a very narrow decision before, but all I'm saying is that from the Chancellor Bonnyman said, you're wrong. And so that's what I'm trying to reconcile as, and said that you really can't look at it that way. So that's where I'm struggling with it, to say, well, is the Chancellor wrong? Personally, I would love for it to be, I'd love for council to be clearer, I'd love for the courts to be clearer, but they're not, and that's why we're here.
Well, I'll answer this way. First, every case comes before this board on an ad hoc basis. You look at every circumstance. And so it is possible that another case might have been life and safety driven. I don't know the specifics of that fact. All I can say to this board, if you look at this piece of property here on Gallatin Road and you look at where the sign is now and what's being proposed, I think it's a real stretch to say this is a life and safety. There may be other areas of town with different components that I'm not conversant with. All I can say is I've shown to the board exactly what's there now, exactly what's being proposed. The business necessity, I think my client has addressed. If this board feels without any question that it's a life and safety issue, then I think you'd have to direct that in your vote. I think that's a little bit of a stretch, although I understand the argument on any non-conforming use. If it ends up being life and safety, you're going to get denied either by some administrative board or by some court. My respectful opinion is if you look at this one, I think it's a little hard pressed. I do think that in this case, if it's a life and safety issue, you're going to hear from the residents in that area. You've heard no opposition to my knowledge from residents there. I think that's the opposite of the case that came before you that went in front of Chancellor Bonnyman. I think she's a very fine chancellor, but I think those facts are distinctly different.
That's helpful.
So I have a question about the grandfather clause and how it's applied here. Bear with me because I'm a novice at the legal part, but isn't the grandfather clause intended to protect people in the situation of property owner from let's say a zoning change or a classification that prevents them, that under other circumstances would prevent them from doing what they are currently doing, to continue the use as they are?
That is correct.
So in this case, hasn't the government stepped in and said, you are now conforming, whereas before you weren't, and so you had these grandfather clause entitlements, but now that they're conforming, why do they need the grandfathering?
With all respect, it's the exact opposite of what you said. Before the enactment of the section read by Mr. Herbert, it was totally appropriate. There was no question. The used car sales, the sign, a sign out front, someone said is a sign, a sign, a sign. I think that's what the law is. But my point is, when this enactment came in effect in May of this year, what it says is you are now legally non-conforming. You've got a sign out there in an area where you can no longer allow an LED sign. It's permitted with conditions. And so what was there and appropriate is no longer legally conforming. It's legally non-conforming because of that enactment.
I understand.
And then our reason is that the business used car sales and the sign, which is part of that use, are legally non-conforming. The staff has confirmed that. And as a result of that, we're entitled to replace or repair this sign with a sign as a sign as a sign. That's our argument.
Gotcha. Thank you.
I'd like to ask a question. You've owned this property for 2.5 years, correct?
Yes, ma'am.
Okay, so this new law came into effect in May, and I think for the benefit of our audience, there's an important element here. The amount of time that it takes for you to plan that you're going to do the sign, get the drawings done, all of those aspects, it does not happen overnight. And so I kind of want to know when you started wanting to implement this new sign moment, and how did that coalesce with the passage of this new?
The first drawing was done on May the 8th.
Okay, so this came before the law was actually done. Okay, so there was an expectation that you were going to proceed, and you've already made a huge investment in doing that before this law got passed. Okay.
Just to be clear, the LED is not existing, correct? The sign is existing, but the LED portion is not.
Correct, yes, sir.
Mr. White, I know you've covered the item A part. With respect to the variance, I think I just woke up and smelled the coffee. The sign's going back in the exact same place, and therefore the variance is covered by 137208 as well.
That's exactly right.
No movement of the sign.
It's the same argument we say if 137208 applies as we argue it trumps everything, including the distance, yes.
Okay, thank you. Unless we have any other questions, I guess we could hear from the opposition and save 458 for rebuttal.
That's fine. I did want to clarify one thing, Mr. Chairman, and that is that it's of record down here that the origin of my client's request predated this change in the law. Even for those of us that deal in this area of the law with some frequency, you're totally somewhat caught unawares by what the Metro Council may do in their wisdom. So the client was underway before that ever came about. Thank you.
I have a question for John Michael related to that. Someone has plans to do something and they don't submit it to us, or did you submit it? You just drew up the plans.
The plans that my client was, my client had been in contract relationships with Jocelyn Signs back in May. Okay. I don't think the staff down here was aware of it at that time. They became aware of it long before today, but...
Right. But so when the council passes something, I don't want to put a hypothetical in there, but under this scenario, since there was no contact with staff, there was really nothing. This law applies to them.
I think that's exactly right, and because of just the way you said it, there's probably no contact with staff that would have proceeded that, because there would have been no need to until you had all the ducks in a row from a business perspective. They would have had no need to come down and start the permitting process necessarily.
The reflects the appellant has 458 remaining, so we'll hear from other parties interested in this case. And ladies, anyone else wish to join these ladies at the table? Okay. Ladies, you'll have 15 minutes to present.
My name is Mina Johnson, MINAJOHNSON. I have not prepared to argue under non-conforming and conforming use. However, one thing I want to point out is even though this property become legally conforming under the new council ordinance, sign ordinance has been there. So if applicant were to apply for LED sign in that location before May, it would have been denied based on the distance requirement. The council sign ordinance requires 100 feet minimum distance in case of LED sign from closest residentially zoned property, and 25-foot additional distance each on additional foot. So in this case, it is 9 foot high, so it would have been 225 foot. And some say, yes, they made a good argument. Yes, what matters? The residential zoned property is a cemetery. What matters to me is in the residential zoning area, there are several usages, not only cemetery, but also greenway, parks, church, to name it, a few. So if you allow cemetery because on just overseeing a non-conforming use and disregard every single metro sign ordinance and distance agreement, if you were to allow this permit, you will be potentially opening up another potential lawsuit. If another person wants to have LED sign across from the park or greenway, they will argue, what's the difference? Cemetery, greenway, there's no house. People come visit, but you allow LED sign across from cemetery. Why not allow LED sign across from greenway, across from parkway? And you will be opening up whole new arbitrary, new zoning ordinance, essentially rewriting metro sign ordinance. So I will argue for that point, please be careful what you are allowing and not allowing. Also, it's kind of sideline from what you have been talking, but I want to make one point. I've been involved with Nashville Next. Nashville Next is a general plan updating process. We are planning the future of Nashville next 25 years. And we have asked so many voices from citizens and what you want to see in Nashville 25 years from now. And of course, people always want safe community, strong public school system, and efficient government. And on top of that, very interestingly, people always said, preserve and emphasize unique characteristic of Nashville. What is unique characteristic of Nashville? Is LED message board is uniquely characteristic of Nashville? I don't believe so. So if right now you have a power to accept and address majority of the citizens' voice by not allowing this type of sign, especially coming near the residential zoning area. I have been involved with LED sign. We have been trying to keep LED sign away from residential area past 8 years. So please do not allow this and chip away our residential area protection.
When you say we, who do you mean?
We, meaning we do have community leaders group. We exchange ideas.
Who are these people? I mean, what group are you representing?
I'm not representing. I'm sharing the idea coming from those people.
Do you live near this sign in the cemetery?
No, I don't. But it's not the point, because you allow those signs in one area. It will come everywhere in Nashville.
No, everyone has to come in front of this board and make their case. We see things on a case-by-case basis. We're not rewriting the sign code. We might decide to give a variance. We might not decide to give a variance. That's why we're here.
Yes, I do understand. That's why I said the decision will be arbitrary, because one area you may allow, one area you may not.
For the record, nothing that this board does is arbitrary. And our lawyers defend us in court very often, sometimes, but we do not act arbitrary. We have laws, we have rules that we follow, we make discussions, but we do not make arbitrary decisions, and I don't want anybody to say that we ever do.
Mr. Ewing, I am saying just in case you have accepted this application, because you are overriding metro zoning law, because metro zoning sign ordinance clearly request distance requirement. In this case, it is 225 feet from residentially zoned property. But if you were to allow this sign 178 feet, I don't remember exactly, but within 225 feet of residentially zoned property, you are overriding or allowing arbitrarily, and which you will not, I hope you will not deny the application, but I was simply saying if you were to allow this.
Hey, ma'am, because I don't want any confusion here. First of all, I don't know how this commission's going to rule. But secondly, I don't think anyone on this commission is going to rule that somehow we have the power to override Metro's sign ordinance. None of us think we have that power. The question is whether Tennessee state law overrides Metro's laws, which it does. I mean, well, yes. I mean, so we're not going to take a position against Metro's sign law. We're not empowered to do that. We are unfortunately obligated to determine whether Tennessee trumps Metro's laws. So anyway, I just want you to know, none of us have a beef at all with this, distance.
Yes, certainly I understand Tennessee non-conforming statute. If we were to accept Mr. White's argument, it will invalidate all of Metro sign zoning, because in his argument, any and every single sign, existing sign, can be transferred to LED sign, regardless of which zoning.
I guess maybe I want to make clear, too, some of the things that, as I'm sitting here hearing them, the point of this board is to make a practical application where it is deemed necessary by the board of different ordinances, and not all ordinances fit the same box, right? So this is why we exist in a lot of respects, is that there are moments that it is not a practical application of this particular situation. I'm not saying one way or the other, but I want to be clear to our audience and to everybody as a part of the record that this is why individual cases come to us. It's a case-by-case basis, and the decisions that we make don't necessarily apply across the board. We're not overturning anything that council has put into play. We're just considering this particular situation. Do you understand what I'm?
Yes,
okay.
Yes, ma'am, I'm following. Okay. But I'm just asking, by doing so, you are potentially disregarding Metro sign ordinance. Because one sign, yes, it is case by case, but if you accept one sign in one particular location, under the same circumstances, you must accept another sign at the similar or same circumstances. Because otherwise...
That's not necessarily true.
Not necessarily. May I add something? Mr. White even quoted that in the past you have allowed some of these and that he thought you should do it again. So I think there is some precedent set when you allow a similar circumstance and then when a similar circumstance comes before you again, I have heard you say that we've done this before, and so I see no reason why we shouldn't allow it again on certain situations. So I think there is some precedent that is set when you do allow a variance to a Metro code. Whether it is going to be trumped by the state or not, it's on the Metro books. And that is what most citizens, we are relying on the protection of our elected officials that we have elected to represent Nashville.
Could you please state your name for the record and your address?
I haven't spoken yet.
But that's okay, you've already spoken now.
Yes, I'm Charlotte Cooper.
Mm-hmm. And where do you live?
I live on Trimble Road in Nashville. I do not live near the cemetery, but I think it affects other situations, and so I am here to speak in defense of the code, the B part of the code. Are you ready for me to speak, or do you have more? No. Okay. Are we? Okay. Cemeteries are zoned residential for a reason. It is the final resting place for the majority of us, and it should be sacred ground and protected at all costs. Even though there are no living individuals residing in cemeteries, we still should show respect and reverence to those who have passed on. They deserve to keep their dignity even in death. We also need to be respectful of family and friends who visit the grave sites frequently. I spend a lot of time in cemeteries, mostly old cemeteries, because I do a lot of genealogy research. And these cemeteries are peaceful and serene, just as they should be. How disappointing it will be to look up and see a brightly lit, glaring sign shining down on the grave of one of my ancestors, or perhaps one of your ancestors. The code passed by our elected officials permits commercial to abut residential, but protects that residential property with the height and distance provision for LED signs, allowing exceptions, exemptions, or variances for LED signs being placed closer than the code allows, even for residentially zoned cemeteries, chips away at the integrity of the intent of the code that was passed to protect both individuals and property. Each time you allow one of these variances, you are opening the door a little wider for more requests. I urge you to disapprove this request. Thank you.
If I may, I do have one more thing I would like to add. Since this argument will come down to Tennessee statute non-conforming use, and I would like to add, I don't remember exactly which, but Tennessee statute also allow local jurisdiction on certain sign. So if you are allowed based on Tennessee statute non-conforming use, you will eventually invalidating metro sign statute. So, but also in the Tennessee statute, there's one writing, it says local government may have jurisdiction on sign. So please keep in that mind. Thank you.
And I do have relatives that are buried in the cemetery across the road.
Do we have any other questions? Okay, well, thank you very much. And the applicant has 4 minutes and 58 seconds of rebuttal, I think.
Yes, sir.
Mr. Chairman, first, I'll comment in light of an inquiry by the board. My client not only was underway on this matter in May, but I'm asking that an exhibit be given to the board where there were actually drawings prepared the day May 8th of 2013. It wasn't the first time they thought about it. They've actually got the first drawings they received from the company are May 8th, and I'm asking that be made an exhibit in this case so you'll know that it wasn't just a comment we were talking about at May 8th. They've been down there long before then. They've got their first renderings. The second thing that I'll ask is that if we can look at the language again, this is the Metro Zoning Ordinance, which I think basically takes this head on, 17.40.690C, and it provides that if the alteration of a sign is desired by the owner of the business existing on the effective date of the ordinance, which is May 2013, quote, this will not apply and the sign may be altered or repaired to any extent. I don't think it can be any clearer than that. I think that's right on. That's just if there's no state statute. The next thing I'll comment about is the state statute trumps, and I don't think anybody's going to argue that TCA 137208 does not trump any local ordinance or statute, especially one that would be contrary to it. And I've mentioned under 137208 that language which this board's conversant with, but is very clear about 3 requirements. The first requirement was it legally non-conforming. You've got the letters that confirm it. Is it a nuisance? I think it's clearly not a nuisance. There's been a sign there far larger, far higher, far more of a distraction for some time. And then number 3, is it necessary or appropriate for the business? My client has testified to that. And I want to go ahead and address another issue. One of the board members said, what about this Chancery Court decision where they dealt with life and safety? Every case, as was mentioned by Commissioner Ewing, comes before this board on its own facts. You have not heard one testimony about life and safety at this issue. None. You can't just come up and say something might. You have to have somebody testify that there might in fact be an issue. Not one comment from the people that came up here in opposition to say, by the way, I've driven that area, there's a concern. With all respect, the opponents live in the Green Hills area. It's a wonderful part of town, but it's not this part of town, and there's certainly nothing before you right now that would justify any finding that this would be a life and safety concern. It doesn't exist. It can't be made up out of whole cloth. There's been no testimony. It's not there. I also comment in the greatest respect, my client's mother and father are buried in that cemetery right across the street. Not relatives, not other, just his immediate family. His mother and father are buried there. For whatever it's worth, he asked me to make that comment. We'll answer whatever other questions, but I think it's extremely clear the Metro ordinance by its own, in my opinion, allows the owner, if he desires it, to do this type of alteration. Secondly, the state statute trumps it. And finally, on a life and safety issue, I would like to hope that any lawyer or client would not come down and advocate something that might be a life and safety issue. But in this case, there's absolutely not one scintilla of evidence that it might be any kind of issue whatsoever. With respect to the usage, it's far more attractive. It's 2/3 of the size. It's in keeping with other signs that are coming up and down that area, including the CVS sign, which is extremely close, in order to stay competitive. So we appreciate your courtesies, would respectfully move that the board approve it, as was mentioned by Mr. Hargis at the front end. I think it ought to clarify that the action of the board covers both the item A and the variance issue. I think they're both covered by the same 13.7208. They're both covered by the same reading of this Metro ordinance, which I've read to you, 17.40.690C. Thank you for your courtesies. Respectfully ask for your approval.
Any further questions?
There was one more thing that she brought up that I'd like you to rebut. She said that you're arguing that any sign anywhere should be allowed to be changed to an LED sign, and is that part of your argument?
That is not. You have to take, this board has to take every decision, as does every court, on a case-by-case method. You first have to find out, was the use legally non-conforming in the first place? So everyone is taken up by its own. If you said to me, is every legally non-conforming sign able to be addressed by this board? The answer is yes. But then you have to come forward and show that it's not a nuisance. You have to come forward and show that it's basically necessary for the business. So you've still got those predicates. But I will say that any sign that was legally non-conforming before this May 2013 enactment, yes, that could be considered by the board. Doesn't mean you'd have to grant it. Everyone's on its own merits. You're setting no precedent other than case by case, as I think everybody here knows.
Thank you.
Thank you.
It's another question before you go. It's evident to me that the sign is needed and vital to the success of that business. What about the LED portion? I mean, how vital is that be LED? That's the one area that I'm a little bit gray on right there. Because I understand the entire sign is not LED, correct?
Yeah, the LED is only 2.5 feet tall. So, and then that's an affordability factor for us, of course. Affordability. I can't afford anything any larger than that. But yeah, I mean, it's gonna be a whole lot easier than having to go out there and change letters on a sign. If you, I guess if you still got the pictures they had before, looking at the signs up and down that street that have manual reader boards, excuse me, there's nothing on them, or there's phrases up there missing letters, because folks just don't take care of those signs as they're supposed to.
Do you see that LED thing as being a constant changing message out there? I'm talking about like
a constant flashing.
Right. I mean, you have to abide by any LED rules.
Sure.
You have to be stationary for a certain length of time,
sure,
or whatever. But that's not like a. I'm not going to assume anything. I want you to tell me what you're going to do with that LED board.
Well, the intent is to maybe just place phrases up on it. What I wanted to do when I talked to Jocelyn Sign about designing this sign for us, of course, I can't afford the full color sunburst things blowing up, big fine pictures. All I wanted to do was be able to put 3 lines of text up there, just as I would on a manual reader board, where you have to physically go out and change the letters. So it's our intent just to maybe have 3 letters of text, three sentences of text, and maybe change those. Let them change every 4, 5, 10 minutes, whatever. Of course, I don't have it yet, so I really don't know what my options are going to be. But like I said, the intent is not to have something flashing all the time. That's not the intent.
Okay.
But the fact that you're governed by an entire set of rules on LED is in your consideration as far as what needs to be done with that board and how it can be utilized. So, correct?
I'm sorry?
Everything about what your intent is to use it and abide by
most certainly.
restrictions
Yes, ma'am.
of having
Most
an
certainly.
LED. Okay.
We've been in business for 10 years, and we need to be there for another 10.
There you go. That's important to know.
Unless we have any questions, I think thank you very much. Before we close the public hearing, I'd like to ask our legal counsel a question, and it stems from the fact that the zoning administrator based his decision on this new BL 2013-418, but the applicant has cited Metzo 17.40.690. I'd like to get your opinion, if you would, on the interplay between those two, if you would.
Okay. I think the overlap or interplay, as you termed it, to look first at the May 2013 ordinance gets into the idea that certain auto sales, auto services uses create scenarios pursuant to this new state or city law where the digital signs, like we're talking about, wouldn't necessarily be permitted. In an instance like that, where you had a digital sign or you had certain billboard type signs, that creates essentially a legal nonconforming use, whether it be at this property or anything else where there's been that change. Once you have created a legally nonconforming use, as you know from plenty of other cases that you've considered, you've kind of bled into that grandfathering analysis governed by the state law at 13.7208. Specific to this particular case, that analysis under subpart D is it a legally nonconforming use? Is it a nuisance? Is it a business necessity? Those are the questions that wind up getting analyzed to see if that works that way. And you've heard the arguments from both sides on that subject today and can weigh your determination accordingly. As how it then factors into 174690, which is our code section that deals with nonconforming signs. Both sides, the proponents and opponents have talked about the fact that the key language desired by the owner, it's there for you to analyze. Are you of the opinion that this is desired by the owner and that is a sufficient degree of basis by which to allow the property owner or lessor, as in some instances, to utilize this kind of sign on the property if they enjoy grandfathering protections and if, in fact, it is simply desired by the owner of the business existing on the effective date of the ordinance, then the restrictions do not apply under 164690. I'm sorry, 174690. Now, I know that's a little bit of an overview of the interplay there, but I certainly welcome any specific questions you may have.
No, that's very helpful. Thank you. With that, unless anybody has any other questions, I'd say let's close the public hearing and start debate.
I have a question for Joey. It was mentioned that there are other LED signs on that street. The CVS was mentioned specifically, and how are those allowed to be there, and what's the difference between the LED signs that they might have and this one?
Those LED signs that are not car lot in nature are covered under the zoning code and are allowed in CS.
Okay.
Now, the one particular CVS may or may not be grandfathered as to spacing to residential. So think about those existing signs. That section of the code that talked about distance to residential zoning, that was an earlier amendment to the code. There may be older grandfathered LED signs in the Madison area that don't conform to those and don't have to, honestly, but presuming it conforms. It's not this situation that is just specific to car lot uses that's there.
All right. From a conversational standpoint, we've got a lot to work with right here. insofar as I think this Metro Ordinance 690, from what you said, John Michaels, one of the issues that I'm having, of course, is that there's a dual issue here. One is that it is desired by the owner of the existing business, but where I really feel it's important to look at this particular Metro piece is that the effective date of the ordinance codified in this title. This piece, as I understand, of the code existed prior to and gave protection, grandfathering protections under this sign. Is that correct?
That's correct. If you're talking about the 690 portion, I think the notation at the bottom of the actual copy of code indicates that was passed by a 1996 base ordinance and part of the 1997 codification of what is sometimes referred to as Metzo, or our whole zoning code scheme going all the way back to 97.
So this had been contemplated prior to this change, that there may be issues that needed to be protected. So completely emotion and all these other things aside, it seems to me that even Metro Council has considered and applied their theory that sometimes their code gets implemented at a time that is not necessarily conducive to everybody else's business schedule. And so this gentleman has been not only contemplating, but was already in motion and had retained the sign company to proceed with the design and implementation before this was ever brought to the board. And so I feel like there's an additional protection in some respects to the fact that he had contemplated it before it became code, right? Before it was allowed in May. And so on top of where I think he's been protected from a grandfathering side, I also feel like he's protected by Metro's own ordinance.
But I guess the question is if he had applied before this ordinance, and we can ask the zoning administrator, but based on actions prior, my thinking, would it have been denied under the reasons that we've seen before that said previous court orders caused me to deny this?
Probably. I didn't analyze it, but if I had, I probably would have drawn a distinction. And those previous court cases applied to billboards, off-premises signs, which I see as being distinctly different from what's being requested here.
Because there's a lot of language in the statute about the owner and their intent and what they use, and if this is necessary. Usually a billboard is kind of off-campus advertising for somebody else's business. And so I think they went out of their way to say a sign and a business kind of go hand in hand, and oftentimes that's really needed, and there's a little bit more protection given in these kind of cases, particularly with state law.
Is this not really a two-part case here? I mean, don't we really have two issues here?
Well, we do, and I think
The
Joey asked us to
sign,
make
and
the
then we
motion.
have the LED.
I guess it depends on what order.
Yes, sort of. I was thinking it was a two-part item because you do have the challenge to the sign, but also the variance on the distance issue. So yes to that question, maybe not for the reasons that we were both thinking, but I understand where you're coming from.
Yeah, I mean, if it is true, if there were no LED component, then there would be no item A. Is that correct?
Actually,
Correct. Well,
I was thinking of the distance variance.
but it wouldn't be an item A. So
No, it wouldn't be an
Just
item
be
A.
there.
It'd be just the variance
It'd
on the
be-
distance, and then there is the grandfather clause there to say they're just replacing a sign. This
Already
to me, all this completely comes down to the LED component. I mean, that's.
And let me just clarify this, that generally speaking, but for the fact that this is an automobile-related use, in a CS base zone district, generally speaking, an LED sign is allowed. So again, my determination started and ended with the new Council Bill 418.
John, excuse me one second, Chairman. I just want to make sure that it's completely appropriate to continue questioning the zoning administrator. I I don't know that the appellant has an issue with this. I just want to make sure that we're all above board. And
Well,
I know you asked him a direct question, but I just want to make sure that we're within our own rules. And
I think it is up to us, and if somebody would like to make a motion that we come out of discussion so that we can ask questions of our help, I'm perfect. I'll make that motion because I'm interested in their answer.
Before you do, in your rules say you're allowed to question a witness at any time.
Okay,
You do not.
great.
So we don't,
No, I don't have a question. I didn't mean to cut you off. I just
Nothing like our sergeant at arms.
well. I can see the appellant over there discussing the points you're making. And they're like, well, let's see what he says. And I just wanted to make sure that we weren't, denying rebuttal or anything like that. That's all. I don't have a question.
I guess in my simple mind is if there were no LED portion of the sign, would there be an appeal here today at all?
There would not have been an item A appeal.
Right. But, I mean, insofar as the sign itself,
No,
would there be a variance?
there would not, because those variances are driven by the electronic component.
Okay.
Yeah, I mean, and that was why I was asking the questions about the court case, and then asked the zoning administrator about, if it weren't, if the metro ordinance didn't exist, what would be his opinion on the sign itself, because we have struggled with and have kind of had different answers, and most of the answers are very close. They're kind of 4-3 answers of is an LED sign just like another sign. And we had, and it was talking about a billboard, and the billboard's case, this board has said, yes, it is the same, and we had a court say, no, it's not. And so that's why I was saying, well, this is an LED message board, and that's not a billboard, and it all kind of comes down to the lack of clarity from council and my Metro Council, in my opinion, on defining signs as signs evolve, and just defining very clearly what types of signs they're talking about. But that's just the technology getting ahead of the legislation. But it does come down to, is it the same type of thing or is it not? In my mind.
Based on that argument, and I respectfully understand where you are, I think there's some major distinctions between this particular situation and from a not picking sides about it, billboard non-conforming use and business non-conforming use in this particular area. I mean, I think there will be a day we come up with this same situation across the board. I think the one sticking point for me is particularly that he has protection even under Metro's own code about being able to do business until such time as Metro Council changed the code. And in the midst of this, he was already in the process of making this change. Now, while there may have been the residential issue, which is why it's here, because there are common sense moments that we have to contemplate as to whether Metro Code generally applies to all circumstances. I think in this particular instance, they have contemplated that somebody was in the middle of a business decision, and they are protected during this process that it had been. So I struggle with the fact that even in Metro Council's own wisdom, that we don't give this a different kind of approach. I mean, I certainly feel like they have protected the fact that he had desired this during the effective date of the ordinance as it was codified. And so I think there's a whole different argument on top of whether or not it's even allowed. I think whether or not it was protected before it became the law. Do you understand what I'm saying? I think we contemplate all of the issues, but I think there's this really special application in this particular situation.
Yeah, but I guess what I hear you say is that if the Metro ordinance doesn't apply because this, let's say the effective date of this sign was before that, then the rules that would apply are the grandfather rules. And I don't, you can go down that road, it still comes down to, in the grandfather rules, is the message board enough like a billboard to say that the logic of the court is valid, I think. And so,
But if it's allowed in CES across the board in other businesses, and it's just particularly this business that has been singled out, it's allowed up and down that road.
That's a good point. That's a good point.
Okay, so
No, I
this
get that.
particular business has now been singled out by council as being not allowed.
Because CS is not MUL. It is allowed.
But it's allowed for every other
Right.
business. I think it's very singular.
Can I also just make a comment to 13.7-208, just because it continually gives me heartburn, so I want to bring it up every time. The argument that Metro made in front of Chancellor Bonneman, they never made in front of us. It was something that was created after this body, and it's never been made to us since. I mean, nobody has stepped in front of us and made that same argument that Metro Legal, no offense, kind of created after us. And so that just kind of gives me heartburn for one thing. And then two, I do think it's important that that case is still being appealed. So it's not like it's come to a final resting place. What you have is a chancellor making a ruling that's now still subject to appeal.
But not based on our argument.
Yes, based on new arguments.
Chairman, and speaking of 208, it's under D, there's the three issues, and it seems like only one of them we are left with the ability to find as fact, as the other two seem to be. Well, the first one, property must be legally non-conforming. That's just black and white. That's just, we don't decide that. It must not create a nuisance, which that seems to me to be the only thing that we're in a position to decide under 208, and the change must be necessary to business. It also seems that we're not in a...
Very subjective.
Yeah, unless it's just an outlandish or, arbitrary or capricious argument that the appellant is making. So as far as the LED thing, the only thing, if LED is the only thing that is where it is the essence of the argument, it seems like we only have to decide if it's a nuisance or if it creates a nuisance, which is a big part of Mr. White's argument. I don't know what percentage of us, but I mean, it came up. He kept saying, and that really hasn't been, in my opinion, definitively rebutted that, oh yes, it does create a nuisance. I mean, people have said it, but not how it creates a nuisance. Especially if the LED portion is 9 feet above the ground, which will barely clear the tops of the cars on the lot.
Well, all other things being equal, David, if the nuisance scenario was applicable under CS, then all the other ones that are applicable to other businesses would again be a nuisance in that particular block area, right? So if it's been allowed up and down the street, then the argument for nuisance has not been applied.
I guess my biggest heartburn is I just don't understand how we can have a law that allows everybody to do something except certain segments of businesses or whatever. I just don't see that. That's where my heartburn is.
Yeah, I agree with you. I don't see how we can, if this was a new car dealership, they would be able to have this kind of signage, but a used car dealership or a leasing dealership, if someone wanted to take that a little bit higher, that would probably get thrown out, but not for us to say.
Ironically, we would have to vote against this for somebody to make that appeal. So it just keeps coming back to us when we vote in favor of the appeal, and then that argument never gets made.
But speaking of argument never get made, Mr. White brought up an argument that has never got made either, so we're staying on the facts.
Yeah. Do I hear a motion out of it? I did not mean to cut off debate. I was just...
Have we had any discussion, or are we all just accepting the fact that we feel like a variance is appropriate given the fact that this is a cemetery on the distance issue of the zoning code?
I was late to the party on that one, but it's very telling, well, not telling, it's a very important factor to me that the sign's in the exact same place. So it's almost got to be protected by 137-208 because
They're not moving it anywhere.
Right. It's not like the last case we had where the guy was cutting down the sign and moving it to a
The
better
Kroger
place.
Bill Meat property.
Right.
Yeah, right.
Yeah, I mean, and I think I've said, and I totally have no issue with the sign. To me, it's the question is the LED piece of it, and I think the arguments are quite good in terms of making it different than what we've seen before, and the case before Chancellor Bonnyman. I will say that we've said many times that the argument in that case was different than what was here, but when I read the case, the results of the case, I mean, it was very clear that this hearing was well represented in her remarks. So, I mean, it wasn't like something that was just pulled from the air. It really did reflect, because I had heard it enough through our conversations, and I thought, well, gosh, were we even there? And we absolutely were. So I do want that to be there. But, I guess I don't have a huge problem, but with the sign. But I wish that there were clarity on what what the difference is. I mean, I think that the businesses of Nashville and the sign companies of Nashville and the citizens of Nashville are kind of owed that clarity by the council in terms of firming up what it is they really expect out of these kind of things. But
my position on the LED is that there is some degree of clarity in the silence in the metro zoning. I don't know where exactly it spells out that they are different. In the sign is a sign argument, they're illuminated differently and they function differently, but they are both static and LED are governed by the same light bleed rules and trespass as signs, just as parking lot lights are governed, whether you're a church or a UPS facility. So I think in a strange way there is clarity on LED that by not saying anything they're saying there's not a difference, except that we don't want them here and here, and that to me is the arbitrary part, where they want them or don't want them.
I agree with Chris. A big point in this case is basically they're putting it on the same site in the same location, and I think that weighs a lot, particularly if we buy into the grandfathering clause. The opposition did talk about the light and reflecting on graves and things like that. I'm not sure, given the location of this, and like I said, it's been there for a while. I like history. I spend a lot of time in cemeteries too. The offensive thing, in my opinion, about the veteran cemetery where there are people that fought in the Civil War buried there, including African American soldiers, there's a big railroad track that just goes through the center of the thing. And I just don't, and the cemetery was there first. So talk about being disruptive to a final resting place, but that's another story.
If I were to make a motion, which I'm not, at this point.
Just taunting us or what?
I guess I'm.
Come here, stay home.
I would be a motion such that we approve the signage with the exception of the LED reader board. And I just don't have any basis, because I just don't believe it's right to legislate against one specific or two even more types of businesses that you can do that, but you can't. I just don't think that's right. So that's why I'm hesitant to make that motion. But I do feel like this business is entitled to this sign.
Well, let me ask you this. I may even philosophically agree with you, but I'd be much more comfortable making our motion in the sense that, and this pains me, but the zoning administrator acted in error, but only in the sense that he relied on Metro's new statute but unfortunately, this property is grandfathered under 17.40.690C of Mezzo and also 13.7-208 of the Tennessee statute. Essentially, we're getting to where you're saying it's just under grounds of grandfathering. And because I do philosophically agree with you, that's being fairly robust in our powers.
I thought that was beautifully said.
Yeah, and it's respectful of the issue of ad hoc cases and precedent that I think is what is most disturbing to me, to some, and maybe to others, of, if we approve this, then what does that mean down the road? And maybe we can say, well, nothing, it depends on what comes down the road.
We get to have the same argument again, but more nuanced about something else.
My conscience is clear on that piece, specifically because this really does relate to the 690, that this owner has exhibited the desire and actually proceeded with the design of this sign before that code was ever codified. And I feel like he is protected, and it was contemplated by our wise counsel that this might happen to somebody. So in my opinion, be that as it may, I don't have heartburn about most of these other issues. I think council has implemented something that affected a business owner who had been making this business decision, and he is absolutely protected under this particular clause. Grandfathering aside, all of those other issues, council contemplated that this might happen to a business person, that the investment has been made, and they should be protected. I don't think it has to go beyond that to all the other grandfathering issues, get mired up in all the other court cases. I think our wise counsel made an attempt to protect a businessman or business person in the midst of these decisions when the code changes.
Okay. Is that a second?
Mr. Chairman, was that
That was your second.
was yours a motion?
Did I just second you?
Mine was a motion. Mine was a motion. So I think we have a second.
I have a second.
We've got a motion, a second. All in favor?
Aye.
Any opposed?
I'm going to give it a reluctant aye.
Can you put that in the record? Reluctant aye?
Just put his down a few inches deeper than ours. But anyway. All right, so I think it passes.
What about the variance?
Actually, I'm sorry, I didn't articulate that very well, but the variance is also protected under under the state statute.
You want to do that as a second motion?
Yes, for Joey's sake, I'm going to say that the variance.
I thought that's what we were voting on.
We were voting on that.
I certainly meant to do both at once. I blew it. I meant to do the item.
Two separate motions.
You could have done them in one, but the chairman did not cover the.
Dadgummit. Okay, I am going to make a motion that we approve the variance based on its protection under State Statute 13.7-208 as well as Mezzo 17.40.690. Is there a second?
I second.
Okay, got a motion, got a second. All in favor?
Aye.
Any opposed? Passes.
The Board of Zoning Appeals is adjourned for today. Thank you.